It is the complainant's case that she did not consent to the sexual act, and according to the provision to section 42 of the Sexual Offences Act, a person is said to consent if he or she agrees by choice and has the freedom and capacity to make that choice. To prove the mental element required in rape, the prosecution had to prove that the complainant physically resisted, or if she did not, that her understanding and knowledge was such that she was not in a position to decide whether to consent or resist. This court has carefully considered the evidence tendered by the prosecution, and particularly the complainant, who was the key witness and only one in that for that matter, and the defense raised by the accused person. The other key ingredient for an offense of rape, as we have stated, are lack of consent and then penetration. In this case, on the first aspect, that is the lack of consent, we have noted that PW1 stated that she was incapacitated and could not give any consent to any sexual act. When we go to the second ingredient, that is penetration, we run into problems. To start with, we do not even have any evidence, not even oral evidence as to what transpired, as to whether there was any actual penetration or any sexual intercourse. All PW1 remembers is that she was given some tablets and then she found herself unconscious. When she woke up, she was in a strange room and she did not have her panties on. Now, how would we prove penetration? Number one, it could be by oral evidence. If someone says that someone had some sexual intercourse with them that caused penetration, and in this case it needed to be genital organs. In our case, unfortunately, we do not even have that oral evidence because PW1 was not certain. The second way of proving penetration would be by forensic evidence, where we have evidence collected and examined, and if we have, for instance, injuries or maybe spermatozoa or any other fluid which maybe have been deposited inside a vagina, then we can conclude that there was some sort of penetration. The court could also resort into some circumstantial evidence where we can say that the circumstances outrule any other circumstance. In this case, we also had the issue of the similar facts evidence. We remember that when PW1 reported the incident at Kasarani police station, her statement was taken and then she was sent away because she was told that there was lack of evidence. No action was taken until later on when some clip was seen circulating in respect to the person whom she later on alleged is the same person who was there. And that is when now she was called back to the station and told now she should record her statement so as to collaborate that. Can this court rely on that evidence as similar facts evidence? Unfortunately, it was not also followed up thoroughly. We did not, the IO did not pursue that line because we needed to even have a conviction, and those clips produced in court proving that the person in those clips was the same one in this case, and then we could relate the same to this accused person and say that he must have acted in the same way as he did in that other situation. We did not have that evidence in court, and therefore, in the absence of either oral evidence, forensic evidence, similar evidence, or strong circumstantial evidence, the court finds that the first count of rape cannot stand. Most probably the accused person may have had the sexual intercourse, but this is a criminal case and the court cannot rely on probabilities or an assumption. In a criminal case, all the particulars of the charge must be proved, and each one of them must be proved beyond reasonable doubt, not just on a probability or just assumption. And no matter how offended the court, the society may feel, we cannot convict someone on a mere assumption or just out of sympathy. And therefore the court finds there wasn't adequate evidence to get a conviction in the first count of rape.